Morning.
Good morning.
Good morning. Just checking sound. How y'all?
Good. We just need your video, Miss Smith.
Okay. I thought I had. Okay.
We got.
Okay. Don't turn to stone. Sorry. I see me. So.
Gosh, my computer's not gonna do it.
Skype is not gonna work. Our internet. I don't know if this has something to do with. We had issues yesterday.
Okay.
We got issues today. So I've messaged, and the internet's down there. So
Okay, so get Brian.
sorry.
That's okay.
Did you? Rodney Zell just asked for the meeting link. Did you get his email?
I did not. I can't get my email to come up.
Okay. Let me.
Hector, can you forward it to him?
Yes. Let me see.
We'll forward it to him, Paula.
Okay. Thank you.
Rodney Zell. Let me copy that email address. Copy.
Do you know what May calendar looks like?
How about it? 18? Okay.
Yeah. And there's June's. There's 16.
Okay, so we don't need more on.
We got plenty of room for
Go to July.
yeah.
And John Carson has also just asked that the link be sent to him. I think he's doing that in the chat room.
Okay. Let's see. Hold on.
Thanks. I know what I'm doing. I'm just I see a little chat thing. So whatever it is.
Hey, Paula.
I'm sorry. And that one.
Okay. Let's see. Let me get back to that.
Go ahead and make a sheet.
All
We
right,
just don't
so
have
July.
August and September, November and December.
Okay, so July's pretty open.
Yeah.
All right.
And so is August, September.
Mr. Carson, you are on the call.
Hey, Paula.
Just-
On. Let's see. On Martinez.
Uh-huh.
Number 16, the clerk's record had him as pro se. So
Yes.
his attorney did not get notice of the hearing.
Okay.
And they emailed this morning saying that they would be asking for a continuance. And I know that was the one with the interpreter and all.
Yes, she's online and we had 2 witnesses lined up, so I'll let them know. We don't have a problem because we didn't realize he had counsel either. Who is it, out of curiosity?
David Rufus.
What was it, Desiree?
Um,
Hold on, Paula. Let me get that name for you.
Okay, thanks.
It's
Devin.
Devin Rafus. Do you recognize that? It's Rafus is his last name.
Okay, great. Yeah, we don't have a problem with that. And if the interpreter, she's listed as an attendee. I don't know how to speak with her.
Okay.
All right. We'll move her over and hold on just.
Joanne Stivers is the interpreter.
All right. She should be coming on right now.
Okay.
There we go. This is Joanne Stivers.
Ms. Stivers, this is Paula Smith, the counsel for the warden. We have just learned that Mr. Martinez does have counsel representing him in this case. The attorney didn't get notice. They have asked for a continuance, so we're agreeing to that. So we will, I don't think we'll need you if you've got something else you can do this morning, and we're going to put this case over, but we'll be back in touch, and we appreciate it so much.
Okay, you're very welcome. Have a great day, everybody. Bye-bye.
You too.
Hold on, let me. That was Hector. Try to get you straightened out. I'm gonna put you on speaker just for a minute.
Good morning, everyone.
Good morning, Judge.
Good morning. I don't know why I had to put in a password to get into this meeting, but I did, but eventually I got it figured out. So let's call the Tattnall County Superior Court to order, and we have a habeas corpus calendar this morning. There are a number of cases on here, but many of them have gone away. But let me just run through the calendar quickly, and then we'll come back to the top and get started. The first is James Brock against the warden. Is that case ready, as far as we know?
Yes, Your Honor, this should be a wrap up. It was, and he is pro se.
Okay. The next one is Timothy Sapp against the warden. Is Mr. Carson on the call? I have
Been
John
trying-
Carson, the petitioner's attorney.
He's been trying to get on, Your Honor. I don't know if he succeeded.
Okay, we'll come back to that. The next one
And
is
there may-
Fabian Powers against the warden, and I have that marked as continued. Anybody know any different than that?
That's my understanding, Your Honor.
The next one is Willie Kyler against the warden. That's also marked as continued. Anybody know anything different?
That's our understanding, Your Honor. There was an order filed yesterday.
Right. The next one is Christopher Garrett against the warden. Is that ready?
Yes, Your Honor.
Your Honor, can anyone hear me?
Yes.
I've been subpoenaed in this matter. I'm just wondering if I could maybe WebEx back in later, if somebody could give me a message to let me know when I need to chime in.
I'm sorry, I can hear you talking, but I can't see who it is.
Well, can you see me now? There we go, Judge. My name is
Yes.
Dan Morgan. I was the petitioner's attorney some 7 years ago. And I've been subpoenaed on this matter, and I was wondering if I could maybe come back, if somebody could perhaps give me a ring later and let me know when I need to come back in.
Mr. Morgan, we'll accommodate you, but if you'll stick around till we go through the calendar, you might want to be in the first case.
Okay, thank you, Judge.
All right, so just
Yes, sir.
stick with me for a few minutes. The next one is Jacinto Flowers against the state, against the warden. Mr. Zell, are you here? I don't see him.
He is on, Judge. He's on as an attendee. We'll move him over once the case is called.
And
Okay, so it's ready to go?
well, we have a witness in that case, Judge. I don't see him on the list yet, but we do have
Okay.
Mr. Zell.
All right, we'll get to that in a little while. The next one is Ernest Huff against the warden, and I have that marked as continued. Anybody know differently?
That's what we have, Your Honor.
Okay. The next one is Jelani Richardson, which the petitioner or his lawyer dismissed without prejudice a few days ago. So that's off. The next one is Tenace Newsom against the warden. Is that ready to go? We apparently had a partial hearing last August.
Yes, Your Honor. It's just a wrap-up hearing.
Wrap up, okay, and that's ready.
Yes.
The next one is Tai Ming Cook against the warden. Mr. Cook filed a fairly late in the game motion to continue. There really wasn't enough time to respond and get an order to him. Does the AG's office object to that?
No, Your Honor.
Okay, I don't know if he's on this call yet or not. Mr. Cook, are you here on the call? I will get to him in a little while. That will be passed. The next one is Raymond Charles McCoy against the warden. That's already been continued. I think I saw a message pop up from Mr. Carson about that also. The next one is Robert Harris against the warden. That's continued according to my list.
Your Honor.
The next one is, I'm not sure how to pronounce this name, Cheek Ganingwe. In any event, it's been transferred to another jurisdiction, which is good for me because I won't have to learn how to pronounce that name. The next one is Joseph Thomas against the warden. That's been continued according to the list. The one after that is Donovan Cross against the warden, has been transferred to another jurisdiction. The next one is Carlos Martinez against the warden, and we have an interpreter in that case, I believe. And don't know who the interpreter is, but I hadn't seen anybody that fits the
Your
bill
Honor,
yet.
we just, before you got on, we learned that Mr. Martinez does in fact have habeas counsel who didn't get notice of today's hearing. He's asked to continue it. We're amenable, and we've already released the interpreter, and I'm emailing our witnesses now to let them know that it's being continued.
Oh, okay, that's fine. I'll take it off then.
Thank you.
And the last one is Darius Terry against the warden, and that was dismissed on the 18th of April already by order. I don't know whether Mr. Terry has gotten that order yet or not, and if he's available, we'll bring him out later and I'll tell him about it. So is there any reason we can't go back to the top and get Mr. Christopher Garrett case and get Mr. Morgan on his way?
I think we're fine with that, Your Honor. I don't think any of the other cases, we've got all our witnesses.
All right, can we get Christopher Garrett from Rogers on the call?
Excuse me, Your Honor, this is Smith State Prison. Did you say that Tay Cook was continued?
It's gonna be, but I want to tell him about it.
Okay, no problem. Thank you.
And I need from Rogers State Prison, I need Christopher Garrett.
Right here, sir.
Okay, good, you're there, all right. Mr. Garrett, we're here for your habeas petition. Are you ready to proceed?
Yes, Your Honor.
Okay, Attorney General's ready to proceed?
Yes, Your Honor.
All right, just give me 1 second to get my notes organized here and we'll get started. All right, Mr. Garrett, do you intend to testify during this hearing, or do you intend only to argue, or both? You can do both, of course.
Both, sir.
I'm sorry?
Both, Your Honor.
All right, then would you please raise your right hand and be sworn? Mr. Morgan, you may as well be sworn at the same time. Do you both swear that testimony you're about to give in this hearing should be the truth so help you God?
Yes, sir.
I do, Your Honor. Yes.
All right.
I do, sir.
Mr. Garrett, since Mr. Morgan is here, do you have any objection to us allowing him to go first, and then we'll swing back around to your side of the case?
No, Your Honor.
All right, Ms. McCandless, do you want to question Mr. Morgan?
Yes, Your Honor.
All right.
Do you want me to do an intro or just start questioning the witness now?
Start questioning the witness. You can give an intro later if you want.
Thank you, Your Honor.
Sure.
Please state your name for the record.
Daniel Dwayne Morgan,
And what year were you admitted to the Georgia bar?
2001.
And could you give a brief description of your job history?
Well, I've been engaged solely as an attorney since I was sworn into the bar. I think rather fittingly, it was Halloween Day 2001. So during that time, now for 21 years, my practice has consisted primarily of criminal defense work. I mean, I do other things, domestic relations work, some immigration work, but mostly it's been criminal defense work. I've probably represented, well, I don't know how many thousands of people I've represented over 21 years. I've done a couple of stints in the Rome Circuit Public Defender's Office, initially when that got going in the mid 2000s. And for some time, I've had a contract with the state to represent folks in indigent conflict cases. I've tried roughly probably a little over 100 jury trials.
And at the time of petitioner's appeal, about how many criminal appeals had you handled?
Appeals at the time of the petitioner's appeal, my best guess, ma'am, is probably 20, maybe. It may be less. It may be. I honestly don't know. I don't really think of the appeals I've done.
Okay. And how did you come onto petitioner's case?
He was assigned to me initially on a motion to withdraw guilty plea in 2015. I don't recall when in 2015, probably early 2015. We had a hearing on that motion sometime in the summer of 2015, and that motion was denied. We had a rather lengthy hearing one afternoon in front of Judge Walter Matthews in the Floyd County Superior Court. I recall that. And then what happens with the conflict office, or what used to happen, is that the conflict attorneys who were tagged to do motions to withdraw guilty pleas, instead of the conflict division handling those appeals, they often just wanted us to handle the appeal of it, of the denial. And somewhere between 99 and 100% of these motions to withdraw guilty plea are denied. So it's almost, oftentimes you feel like you're doing just a meritless appeal. But that's, I appealed it, and it was timely appealed, and there's a decision that I've just glanced through this morning because I had no awareness that this case was going on until some point Friday when I received this subpoena. So it refreshed my recollection a bit reading through this appellate decision.
Okay. And when you came onto petitioner's case, how did you prepare for the motion to withdraw the guilty plea?
We communicated via writing best as I could remember. I believe he was housed out of county. And honestly, ma'am, I probably still, this case is 7 years old, or the appeal is, I guess, 6 years old. But I probably have a file in storage somewhere. I didn't go pull it out. The best I can recall, we communicated via letter. And then at some point he was brought back to Floyd County, and I met with him face to face. But that's my kind of fuzzy recollection from over a decade and a half, or half a decade ago.
Okay. And do you recall how you prepared for his appeal?
Well, I had the entire record. So the issues that I raised on the motion to withdraw guilty plea, chiefly I contended that his due process rights had been violated because he had requested a psychological evaluation, and that had not been done at the time he went forward with a guilty plea. And that was the gravamen of the motion to withdraw guilty plea, as well as the appeal.
And how did you decide what issues to raise on appeal?
Well, I mean, there were really only two things. I don't recall there being anything else that was in my mind. I thought that, my thought was that we had an argument that his rights were violated because he had a pending psychological, and also that there was some potential ineffective assistance of counsel there for various things. Frankly, it appeared that I believe it was an earlier plea recommendation perhaps was not communicated to him. But I know I argued that on appeal, but 6 years later, I cannot recall the specifics of that, but certainly at that time, I was very familiar with the case. I had the plea transcripts for some time. Those were the issues I saw fit to raise in 2015 and 2016.
So would you consider those the strongest issues?
Well, yes, those were probably the only issues.
Okay. And let's see. When you reviewed the file, did you remember any issues with how plea counsel had handled the guilty plea?
Well, like I said, there was some issue with respect to whether or not plea counsel, frankly, there was some issue as to whether or not plea counsel really understood what he was seeking there, and whether he was raising an insanity defense or whether he wanted a psychological to present in mitigation of the sentence. There's also the issue there with whether or not he had communicated. I believe it was an earlier, I believe it was an earlier plea recommendation, whether or not that had been communicated to Mr. Garrett. And I'll say this about plea counsel: he's certainly a fine gentleman. He left that position I don't want to be accused of ageism here, but Mr. Henderson was getting on up in years and was having having mobility issues and maybe kind of general energy issues at the time. And I don't want to, but I think overall he was probably effective. But that's where that stands.
Okay, so you raised any issues regarding plea counsel that you thought would have been viable on appeal?
Yes, and I think the only thing I raised of the ineffective, looking through that opinion, I think it was mostly dealing with whether or not there had been proper communication of a plea recommendation.
I don't have any further questions at this time, Your Honor, pending redirect.
All right, Mr. Garrett, do you have any questions you want to ask the witness, Mr. Morgan?
Yes, Your Honor. Good morning, Mr. Morgan.
Good morning, Mr. Garrett.
By you testifying, you really refreshing my memory some, and I really wasn't really focused on getting you here at this meeting. It was really Mr. Henderson. Was some form of reason or another he cannot be with us this morning. So, but I do have a couple of questions. I have one like during the appeal process, when you go through the records or go through the file that you had in front of you, do you do any any investigation upon, you know what I'm saying, the things that were being raised? Like, okay, the issues that we were raising for appeal, did you investigate, or how do you investigate the validity of the appeals? I mean, the issues that were raised. How do you prepare for that?
Well, Mr. Garrett, we had the issues that were raised on appeal were also what we raised on our motion to withdraw guilty plea. To the best of my recollection, those were the issues that were there. As far as investigating, if you're asking me if I investigated the merits of the state's case, that's kind of outside the scope of what I'd be doing on an appeal. I don't think so. Really, what we're left with, Mr. Garrett, is an examination of the record to determine whether or not procedurally your rights were in any way violated. So I think, if I understand your question, that's where it is. So the investigation just kind of stops at the written record that we had. And of course, I was involved in the motion to withdraw guilty plea. So in 2016, the issues were very fresh in my mind, not like today in 2022.
Yes, sir. Okay. Now there was one issue, though. I don't know if we raised it or not. I don't have the actual transcripts in front of me, but I know I thought that we had raised the issue of prosecutorial misconduct by the district attorney uh, uh, saying that the divorce between me and Mrs. Monisha Garrett was final. You know what I'm saying, and that she didn't want to be present at the hearing when in fact we were still married, and none of those issues that came up. So therefore, I was trying to figure out how was that presented, was that looked at, or was that even a part of the appeal process?
Well, no, sir. I don't recall anything about your presence of your wife being either at the plea hearing or our motion to withdraw guilty plea. I don't recall that statement made by the prosecutor. I believe it was Mr. Kevin Salmon
Yes,
was the
sir.
prosecutor on that case. But even if Mr. Salmon had said something like that at some point, that would not, and it was in error. And I know Mr. Salmon is a very honorable person, a very honorable prosecutor, but even if he had said something like that and he was wrong about it, no way is that prosecutorial misconduct or any ground to have your guilty plea thrown out.
Okay.
Yes, sir.
But the next one is the psychiatric evaluation.
Yes.
Now, if if I wasn't pushed into, okay, sign the guilty plea, they don't have the state don't have a recommendation, sign the guilty plea and be done with it, because this is indeed Salmon's courtroom, versus Your Honor, can we ask for continuance so we can, until we get the psychiatric evaluation underway, or instead of doing that, and you as an attorney, would you stop or ask for a pause on the trial or the proceedings until you get that psychiatric evaluation?
Well, Mr. Garrett, I mean, that was the crux of our argument, and that's why I thought you at least you had some argument here. I would have never, if I had seen the need for a psychological evaluation to determine competency to stand trial or to raise the issue of an insanity defense, we would have never done a plea if I had been your attorney
Yes.
from the beginning. And that's why, and I hate this for you. And I think, honestly, I disagree with the Court of Appeals decision. And Mr. Garrett, I mean no personal insult to you, but we had a lot of communication. I think there was a basis there for a psychological, and I wish you'd had it.
Yes, sir.
But we did. I'm sorry, we did everything we could do back, or I did everything I could do back in 2015, 2016. I hate this for you.
Yes, sir. Yes, sir. Your Honor, I don't think the rest of my questions was from Mr. Henderson, but Mr. Morgan was just, you know what I'm saying, the only other attorney I had during that time. So,
All right, and
I have
Mr. Morgan,
no further
can
questions.
I ask you?
Yes.
And you may have said this earlier, but on your appeal of the denial of the motion to withdraw the plea, was ineffective assistance of trial counsel, was that an issue?
It was, Your Honor. It was. And so, I mean, so that issue, anything with respect to, obviously, that's why the court asked, but obviously anything with respect to Mr. Henderson is not valid to argue on the habeas, I would think, but.
Yes, sir. Yes, sir. Thank you, Mr. Morgan. No further, sir.
All right, Mr. McCandless, anything else?
No further questions, Your Honor.
All right. Mr. Garrett, is there any reason I can't excuse Mr. Morgan at this point?
No, sir.
All right, Mr. Morgan, thank you for being here, and you can be excused.
Thank you, Judge. Thank you. Thank you, Ms. McCandless. Thank you. Mr. Garrett, thank you.
Yes, sir. You're welcome, sir. Thank you.
Mr. Garrett, let's circle back around to your case. So starting from the beginning, what do you want to say? What argument do you want to make?
Your Honor, it's as the years went by and I've gone over the corners of my mind with the issues of, you know what I'm saying, from the time that I got arrested to the time that I stood in front of Judge Matthews and up until now, sir. There's been this nagging thing about me not getting my fair shake or didn't get an understanding of what these, not only what does the crimes that being put on me in Thrails, but the procedure of how everything was done. You know, I've been in and out of the court system since a juvenile, and I never really took time to understand law at the minute level. You know what I'm saying? Until now, sir. And I'm in my mid-40s, and it just finally dawned on me that, you know, a lot of this stuff I don't speak, I don't understand. You know what I'm saying? So it takes me an X amount of time to buckle down, to sit down and really understand what is this before me, what is this I'm reading, how am I to interpret this? So with all of these charges that was brought up against me, each one I had to take apart and try to understand the language of it, and come to realize that a lot of these things I didn't commit, whether upon my recollection or no. You know, a lot of these things didn't constitute the crimes that they said I committed. So when it comes to being in court, saying, do I understand or do I voluntarily make these say yes, I did it, I did these things, Your Honor, that would be a lie on my behalf because I didn't understand. I was just forced, or I don't even want to say forced. I was just, you know, nudged into just go on and sign it because, you know, you don't really want to stand in front of Mr. Salmon's or the DA, Mr. Salmon's courtroom because this is his court ultimately, you know, and that really, Your Honor, was been the basis of my signing of a guilty plea was fear. You know, fear of getting 160 years, fear of not being able to see or hug my children again, fear of people dying, which they already have since I've been away, you know what I'm saying? So I would like a chance, Your Honor, to either have my sentence fixed, you know what I'm saying? Because even though I might be guilty of some things, but a lot of things I'm not, you know what I'm saying? And I would like to have my fair say in court, you know, to at least express my not my frustration, but my honesty, you know. I just want a fair chance.
All right, sir. McCandless, do you have any questions you want to ask
No, Your Honor.
Garrett? Mr. Garrett, did you subpoena your trial counsel?
Yes, sir. In fact,
what's his name again?
His name is William Henderson. William Ben Henderson. I sent it to the wrong public defender, but they sent the response saying that he had retired, sir, and he no longer works there. And this is the receipt that I've got from the court of Floyd County Sheriff's Department. Signed by Clerk Superior Court, Barbara H. Henson.
So you tried to serve him, but he was not at the public defender's office, and the subpoena got sent back to you. Is that it?
Yes, sir.
And so he was not served.
No, sir, he wasn't.
Do you have an address to serve him at?
I don't have an address to serve him, sir.
Okay.
And I'm pro se, and my resources are limited.
Mr. Garrett, I'm willing to give you some more time to try and get him subpoenaed, but I don't know what else I can do as far as that's concerned. Do you have anything else you want to offer today?
Yes, sir. There was the indictment. It was an issue about the indictment. As far as ineffective sense of counsel goes, the indictment on the true bill indictment of 14-CR-01807 read as follows: false imprisonment, burglary in the first degree, arson to the third degree, criminal damage to the second degree, terroristic threats and acts, obstruction of law enforcement officer 4 counts, and cruelty to children 2 counts in the third degree. Aggravated assault was not listed on the general bill of indictment, and for which the judge had gave me 20 years. And that's what I wanted to bring forth with Mr. Henderson, like, cause I didn't know anything about the general bill of indictment or the charges dealt with, what did they mean, you know what I'm saying? So he should have been the one to telling me, well, this is not on your indictment, but the judge is, you know what I'm saying, sentencing you, because aggravated assault is not on my indictment. In fact,
Mr. Garrett, you're saying that you were not indicted for aggravated assault, but you got sentenced to 20 years for it?
yes, sir.
Is that what you're saying?
Yes, sir.
Okay.
Yes, sir.
There's no superseding indictment or anything that you know of?
No, sir. No, I'm not aware of. That was not included in my discovery package, sir.
Okay. So, Mr. Garrett, I'm willing to give you a continuance to try and locate Mr. Henderson.
Yes, sir.
Think you could do something to find him between now and the next calendar?
Yes, sir. That will be approximately 3 to 4 months.
No, it'd be shorter than that, but I guess we could push it out a little bit further.
I mean, I can do my very best, sir.
All right, when's the next calendar?
The next one is May 25th, and then June 22nd, I believe July 25th.
How
27th.
about June 22nd?
Yes, sir.
Any objection to that, Ms. McCandless?
No, Your Honor.
All right, so how about we just continue the rest of this hearing until June the 22nd?
Thank you, Your Honor.
And Mr. Garrett, it's on you to find the witness and have him served with the subpoena, okay?
Yes, sir. Yes, sir. Understood,
Okay.
Judge.
So I'll make a note of that, and we'll just suspend the rest of this hearing unless, Ms. McCandless, you want to put in your documents now or something.
If I could, Your Honor, if you would me to.
Is that what you would intend to do today, is just put in the documents?
Yes, Your Honor.
Mr. Garrett, any objection to letting the Attorney General's office put in the documents from your case?
No, sir.
Okay, go ahead, Ms. McCandless.
Can you see this, Your Honor?
Not yet. Now I can.
Okay. Okay, so we have several exhibits, and the petitioner's case actually at his guilty plea hearing, it was two different cases combined, so it's going to be records from both of those cases.
So there were two cases that were combined into one plea, is that what you're saying?
Yes, Your Honor.
Okay.
And let's see. Exhibit R1A is certified parts of the record from case 14 CR 1608. Respondents exhibit R1B are records from the appeal for 14 CR 1807. Respondents exhibit R1C is the supplemental record for 14 CR 1807. And respondents exhibit R1D contains more records from case 14 CR 1608, which includes the guilty plea transcript and the motion to withdraw the guilty plea transcript. Respondents exhibit 2 is the appellant's brief on appeal from case A15A2331. Respondents exhibit 3 is the appellant's brief on appeal in case A15A2332. Respondents exhibit 4 is appellee's brief on appeal from case A15A2331. Respondents exhibit 5 is, excuse me, Your Honor, I'm sorry, that's actually Respondents exhibit 6. My screen flipped. It is the unpublished Court of Appeals opinion for both cases A15A2331 and A15A2332. And let me go back. Okay. Respondents exhibit 5 is the appellee's brief on appeal from case A15A2332. And that's all our exhibits, Your Honor.
And the unpublished opinion is R6, is that it?
Yes, Your Honor.
Okay. And give me those two underlying case numbers again, please.
The first one is case number 14CR01608, which was for aggravated stalking, burglary in the first degree, and theft by taking. And in case number 14CR01807, that one was for aggravated assault, false imprisonment, burglary, arson in the third degree, terroristic threats, and 3 counts of felony obstruction of a law enforcement officer and obstruction of a law enforcement officer, the misdemeanor.
Okay. In the documents that you tendered, are the sentencing documents in there?
I'm sorry, could you say that one more time?
Are the sentencing documents
Yes, Your Honor.
within the record you tendered? Okay. All right. Do you have any objection to those documents being admitted, Mr. Garrett?
No, sir.
All right, they are admitted then, and we will continue the rest of the, do you have anything, I'm sorry, do you have anything else, Ms. McCandless, for today?
No, Your Honor.
Okay, so we will continue this hearing until, what did we say, June 22nd?
Yes, sir.
And Mr. Garrett, you will do your best to get the witness subpoenaed by then and have him on the next call, right?
Yes, sir.
All right, in that case, we will be in recess in this hearing then, and Mr. Garrett can be excused.
Thank you, Your Honor.
Your Honor, if I may, I think Mr. Carson had sent a message via chat indicating he may want a continuance. I just saw it briefly and I don't want to misstate anything, but I just wanted to
Yeah, I
pass
thought
that
I saw
on.
something too, but think he had 2 cases on this calendar, and I'm not sure what he's talking about. Mr. Carson, you there?
Hey, Judge, they just added me.
Mr. Carson, you got 2 cases, right?
I do. So McCoy, I was asking to continue. Oh, we already filed.
That's been granted already.
Yes, Judge. And we've got SAP on the docket, and my understanding is we have both witnesses here.
That's Timothy Sapp?
Yes, Judge.
Well, just so
Smith
happens that's the next case on the calendar, so
Okay.
let's move over to that. Is Mr. Sapp?
That's not him, Judge. It's Smith State.
Okay. Well, we'll get him. It'll give me a minute to get my notes going.
This is Flint State Prison. Did you need offender SAP?
Yes, we do. Thank you. Ms. Smith, are you handling the SAP case or is that Ms. McCandless?
Ms. McCandless, Your Honor.
Okay. All right, Mr. Carson. Is your client going to testify?
Judge, I think he is. And also, if I could just ask him, we spoke yesterday. I want to make sure he's still comfortable doing this by video. Mr. Sapp, can you hear me?
Well, it's not optional, so it doesn't matter.
Well, I mean, at some point it may go back in person. I just want to make sure he was okay with that.
Well, you can ask him if you want. I mean, I don't know when that would be going back in person, but
I don't either. Mr. Sapp, are you good going forward today?
Yes, sir.
Okay, good.
all right. And Mr. Carson, do you have witnesses?
I do, Judge. We've got Rex McElvain and Sean Scally on here, both from the Brunswick area. Probably do Rex first.
Well, oh, there they are. Okay. I see Mr. McElvain. So let's get all the witnesses who can testify today sworn in. Would you all raise your right hands, please? Swear the evidence you're about to give in this hearing should be the truth, so help you God.
I do.
And did Mr. Sapp take the oath?
He did. Mr. Sapp, raise your right hand.
Right hand. Swear the evidence you're about to give in this hearing should be the truth, so help you God.
Yes, sir. So help me God.
Yes. Okay. All right. So, Mr. Carson, it's your case. You can proceed.
Thanks, Judge. Judge, we'll start with Mr. McElvain. Good morning, Mr. McElvain. Can you just state your name for the record, please?
Sure. James Rixham McElvain.
Okay, Mr. McElvain. And are you currently employed as an attorney?
I am.
Okay. How long have you been practicing law?
Since 2006.
Okay. And is your practice, or tell me what your practice primarily consists of? What areas?
Criminal defense is my main area. I do some bankruptcy. I do family law a little bit, and I do some civil rights litigation.
Okay. Do you practice by yourself or do you have partners?
No, I have a partner now, Nathan Williams, and I'm actually with Williams Litigation Group since I think 2016. But prior to that, I had my own firm, McElvain Law Group, and during the time, I represented Mr. Sapp. My partner was my wife at that time, Molly McElvain.
Got it. And do you remember what year you tried this case?
2014.
Okay. At the time you tried it, do you remember about how many jury trials you had done at that time?
I would say somewhere between 20 and 25.
Okay. And was this case was in Camden County, correct?
It was.
Okay. And is your practice in Glenn County?
It's really in the Brunswick circuit, and I've taken a lot of cases in Chatham. I take cases in federal court here and in out of Savannah and sometimes in Statesboro. Um, I've been all over, and I'll go to the Waycross Circuit, Atlantic Circuit, a lot of cases. But my main office is obviously in Brunswick, um, and but like the Camden is part of the Brunswick Circuit, so it's common for me to get a case out of Camden.
Okay. And was this a case that you were retained on or appointed?
This was appointed.
Okay. And was this something that you were conflict counsel since there was a co-defendant?
Right. So for many years, I was on a conflict panel with GPDSC to take appointed cases, and that was on and off. And this was one of the appointed cases that came to me.
Got it. And just so we're clear, the case was tried just for Mr. Sapp, right? The co-defendant wasn't
Right. We severed Cyrus Bell from Mr. Sapp.
Okay. Do you remember why it was severed?
Well, I moved for severance, and there was a jailhouse snitch named Harry Jackson that is the DA's office had used over and over again a number of cases. He had evidence allegedly against Mr. Sapp, and Mr. Bell's attorney was aware and had been involved in some of the other jailhouse confessions that this Harry Jackson guy had claimed he had obtained against various defendants. And he had told me about it. And one of the grounds in the motion to severance I filed was that I would not only want to call Bell on that, but I want to call his counsel to testify as to what he knew about in his dealings with this Harry Jackson person. So that was one of the issues, but also just the general grounds of severance that, you can't call a co-defendant unless they want to take the stand. There's all these brutal issues that come up. So I prefer to sever if I can, and I was successful in that. And I can't remember if the state ultimately consented to that, but I did move to sever. I know that.
All right. Prior to today's hearing, Mr. McElwain, what did you do to prepare?
I just pulled up Mr. Sapp's habeas petition. I think he filed pro se. I looked at the Camden docket just generally to kind of refresh my recollection of dates and some of the motions. And that's pretty much about it. I looked at the indictment based off the allegations in the initial habeas petition.
Okay. So I'll tell you that there was, yes, the habeas petition he filed pro se. That was November 5th of 2018. Hard to believe. And then there was also an amended, I think, application filed about a year later. It looks like that amended petition is the one that has 2 counts that apply to you. Have you had a chance to see that?
I have not.
Okay. I'll just proffer to you that it's counts 5 and 6. 5 has to do, it just says trial counsel erred in not filing motions in limine to exclude the testimony of a state's witness who was unable to identify the petitioner and to exclude photographs of firearms that were never recovered. Kind of break that down, I guess, for you. Did you have any strategic, I guess, or tactical reason for not filing motions in limine to exclude that testimony from that state's witness? Do you know what I'm talking about?
You talk about Telvis Brown, the nephew who had taken the pictures of allegedly of these firearms and sent them to his girlfriend or something?
Correct. Yeah.
No, I mean, there was no strategic decision not to file motions in limine. I mean, obviously, if you keep that out, and I felt that there was grounds to do it, I would have done it. But he identified the picture and took the picture. So I thought that it would come in under that testimony.
All right. And then ground 6 on the amended petition is the other one that applies to you, and it says trial counsel erred by not lodging the proper objection or objections to the jury that was impaneled. Do you recall why y'all didn't make a Batson challenge after the jury was impaneled?
I don't recall.
Do you remember the makeup of the jury?
I don't. I mean, it was 8 years ago. I remember it was a fairly lengthy jury selection process, but I don't really recall.
Okay, all right. Turning back to the picture of the guns, do you remember if y'all filed any kind of suppression motion to keep that exhibit out?
I don't believe so. But I mean, I haven't reviewed the whole record, but I don't believe I did.
Okay. And was that a discussion that you had with Mr. Sapp about possibly doing that?
I don't believe so. I don't recall feeling that there were grounds to suppress the picture. You know, the nephew had said that he'd received this bag. He had looked inside the bag and saw these guns, took a picture and sent it to his girlfriend. And I felt like he could identify the picture.
Okay. And remind me, or do you remember, I guess, I know the answer, but were guns ever recovered in this case?
There were no guns recovered whatsoever. So it was really that whole scenario hinged on Brown's testimony, right? Because, you know, he says he took these pictures. He says his uncle showed up in the middle of the night with a bag. So yeah, it was a critical evidentiary thing, but yeah, there's no guns recovered.
Very good. Judge, those are the only counts that apply to Mr. McElveen, so I'll turn him over to Ms. McCandless.
All right, Ms. McCandless, stand by 1 second. I just want to make one note. All right, Ms. McCandless.
Respondent has no questions, Your Honor.
Oh, well, that was easy. Okay, do we need Mr. McElvain any further?
I don't think so, Judge. If we could excuse him with thanks.
Mr. McElvain, unless you want to stick around and learn some habeas law, you may
Let
be.
me put it on mute. Thank you. All right. Thank you, Your Honor. Good to
My
see
feelings won't be hurt. All right, Mr. Carson, and your next witness.
Yes, Judge. We've got Mr. Sean Scally here on the call.
Okay.
And
Yes, I'm
Mr.
here.
Scally, can you hear me okay?
I can hear you fine.
Okay. So it's going to be similar questions to what we just asked Mr. McElvain, so bear with me.
Sure.
If you could just state your full name for the record, please.
It's Sean Kenneth Scally.
All right, Mr. Scally. And are you currently employed as an attorney?
I am.
Okay. And where do you practice?
Brunswick, Georgia.
Okay. And how long have you been in practice of law?
Since 2009.
All right. And can you tell me your areas of practice?
Primarily civil litigation.
Okay. I guess back, well, first of all, do you remember what year you represented Mr. Sapp?
I believe it was 2015, 2016.
Back at the time, do you remember about how much of your practice was criminal defense and appeals?
Very little.
Okay. How did you come to, I guess, were you appointed?
I met with the, yes, I met with the local public defender, and he assigned several appellate cases to me.
Okay. And was this one of them?
Yes.
Okay. When you were assigned this criminal appeal, can you tell me about how many appeals you'd done before that?
3.
And were those capital type cases, Supreme Court type cases?
No, one was a conviction for distribution. One was burglary and false imprisonment. And there's another one that's escaping my mind right now.
Okay.
But no capital cases.
Okay. Was this your first and only capital case you didn't appeal on?
Yes.
Okay. What did you do to prepare for today's hearing, if anything?
I looked back over the brief that I filed, and I looked at the Supreme Court opinion.
Okay. Have you had a chance to review the habeas corpus petition that Mr. Sapp filed?
I have not.
Okay. I will do my best to walk you through that. And so there are 4 counts in the petition that he filed by himself, per se, and then there's an amended petition, and there's just 1 count that applies there. And so I've just got questions, if I could, related to that, or to both petitions. In the original petition, Mr. Sapp raises an issue in ground 1 about not having communication with you before the brief was filed. Can you tell me how many times y'all met before you filed that appellate brief?
We didn't meet. We talked on the phone, I believe 3 times, and corresponded via letter.
All right. And do you recall him asking you to withdraw from his appeal?
No.
And just so the record's clear, did you stay on the appeal, and did you file the brief and see it through?
Yes.
To the opinion. All right. And what was the result of the appeal?
They affirmed the trial court's decision.
Okay. And I think I'm correct. Was it just 1 count raised on the appeal?
Correct.
Okay. And what was that count?
Insufficient evidence.
Okay. And then actually count 2 of the petition that Mr. Sapp filed had to do with that. It just said that it essentially alleges ineffective assistance of counsel. Said that that I think that was argued that it was the conviction was purely based on circumstantial evidence, and so that's count 2. And I don't really have any questions on that. And count 3 had to do with the jury charges and saying that. Or raising, I guess, ineffective assistance of counsel based on not addressing the trial counsel didn't file any kind of objection to the party to a crime charge. Do you remember looking at that issue at all with Mr.
Sapp? Yes, I'm sure. I mean, I don't have a specific memory. I'm sure I would have looked at it if he had mentioned it to me, or just looking through the record, it would have been something I would have considered.
Okay. And I should have asked this earlier, but was the appeal as filed, was it the best appeal you could file and the issues you could raise in your opinion?
Yes.
All right. And ground 4 talks about again, has to do with trial counsel not filing a juror, I guess, within 10 days of the indictment, and had to do with ineffective assistance for not raising that in appeal. Is your answer the same on that? Did you guys look at that and ultimately determine not to pursue that?
Correct. It would have been that I looked at it and didn't feel that it was reversible error.
Okay. And then count 4, again, ineffective assistance of counsel, has to do with, I'm sorry, just looking at the second page. Never mind. Strike that. All right. And then on the amended petition that we filed, I'll tell you that on count 7 had to do with a federal appeal under 28 United States Code 2254. Do you remember, first of all, do you remember having any discussion with Mr. Sapp after the appellate opinion came back down from Atlanta?
Yes.
Okay. Would that have been on the telephone?
Yes.
Okay. And
Yeah, I
did you
believe
guys?
he was 3 or 4 hours away at the time, so I didn't travel to the prison.
Okay. Do you remember discussing with them next steps after the jury verdict was affirmed?
Yes.
Okay. And did you guys discuss filing a federal habeas corpus petition?
No, I believe I told him that he would need to seek other counsel to file any further petitions.
Okay. And did you tell him that did you tell him about his time constraints for filing that federal habeas petition?
I believe so.
Okay. And your representation of him ended, do you remember about what year?
I believe it would have been 2016.
Okay. All right. And then, Mr. Scally, do you practice criminal law at all anymore?
No.
Okay. Gather that as much. Okay. All right. Thank you. Subject need to redirect, Your Honor. That's all I've got for him.
McAllis,
I have just a few questions.
okay.
How did you prepare for petitioner's motion for new trial?
I didn't handle the motion for new trial. The motion for new trial is handled by Mr. McElvain, I believe.
How did you decide to raise which errors on appeal?
I looked at the record. I looked at case law. I considered whether or not there was anything in the record that I identified that would have been reversible error. And that was how I chose what issues to raise.
Did you consider it the strongest issue that could be raised?
Yes.
And I have no further questions, Your Honor.
All right, Mr. Carson, anything else?
Hey, Judge, Mr. Scally can be excused. Thank you for being here.
Thank you, Mr. Carson.
Mr. Scally, I'm assuming you don't care to learn any habeas law this morning.
No, Judge, I don't think that's gonna, yeah.
All right, then you may be excused, sir.
Thank you, Judge.
All right. Mr. Carson, what else you got?
Judge, we're going to have Mr. Sapp testify.
Okay.
Mr. Sapp, you are already under oath, correct?
Yes, sir.
Okay. And you can leave yourself unmuted, I think. Mr. Sapp, have you had a chance? I know you drafted the habeas corpus petition, so it's kind of silly to ask if you reviewed it, but have you also reviewed the amended petition that we filed about a year after that?
Yes, sir.
Okay. And I know you sat here and listened to all of these witnesses testify. I want to kind of walk you through both petitions and get your responses if we could. In the original petition that you filed, it had to do, count one had to do with Mr. Scally and you asking him to remove himself from your appeal. Can you tell the court a little bit about how that went?
Yes, I wrote him and I asked him to remove himself from my case, and it was like I was really just ignored, and so he never did even respond back to me on it.
He mentioned that y'all spoke about 3 times on the phone. Does that sound right? Or?
No, maybe one time.
Okay. What about written correspondence? Do you remember if y'all exchanged letters?
Yes, every time I wrote him, it's like he never responds to me on what I write him about. He'll write me on something else. I have all the letters right here in front of me now, and like he never responded on nothing that I've wrote him.
And did you know? I know this was years ago, but did you know that he was primarily a civil lawyer at the time?
No, sir.
And when I say that, do you know what I'm referring to? Areas of practice, that kind of thing.
Say that again.
When I say he's a civil lawyer, do you understand what I mean? Civil versus criminal areas of practice. Do you understand that?
Yes.
Okay. Yes. And just again, did you realize he really didn't do much criminal law back then?
I didn't know at that point.
Okay, got it. Count 2 of your petition really was an attack, I think, on the appellate brief itself. It had to do with the sole enumeration of error that he put in his brief. Did you guys have a discussion about what he was going? It sounds like you didn't, but did you guys have a discussion about what grounds he would raise on appeal?
No, he never told me that. I wrote him letters trying to find out what grounds he was gonna file and everything, and he never responded to me.
Okay. And did you in fact ask for additional grounds to be argued that were not?
Yes, sir.
Okay. Count 3, this has to do with Mr. Scally. This is, again, kind of piggybacking what you just said, but it has to do with him not raising on appeal the issues of trial counsel failing to file an objection to the jury charges, specifically the party to a crime charge. Did you ask Mr. Scally to raise that on appeal, the fact that the party to a crime jury charge was given?
Yes, I did.
Okay. And did you get any kind of response from him when you asked him to
No,
raise
sir.
it?
No, sir.
And then count 4 of the original petition had to do with filing a demurrer to the indictment. Obviously, that's something that's done right after arraignment. But same question: did you get any kind of response from Mr. Scally when you asked him to raise that on appeal?
No, sir. It's like everything that I wrote him and try to get him to do for me, it's like I was ignored.
Yes, sir. Is it fair to say you guys had virtually no communication, very limited?
Basically none at all.
And then moving to the amended application for habeas corpus, the amended petition, the only one that applied to Mr. Scally had to do with count 7, which had to do with the federal habeas corpus petition. Did you and Mr. Scally talk about what your next step was after the jury's verdict was affirmed? In other words, the appeal was sent back?
No, sir. He never responded back to me on that.
Did you guys have any conversation at all about filing a habeas corpus petition in federal court under 28 United States Code 2254?
Yes.
Objection, Your Honor, relevance.
I'm trying to wonder, I've been wondering what this failure to raise a federal habeas has to do in this state court proceeding.
Well, Judge, it goes to ineffective. He had rights that could be pursued in federal court that were either not explained to him or not pursued.
I mean, don't you raise that in the federal habeas petition?
You do, but I think his contention is that he was never given advice that he had a time limit to file that federal habeas corpus petition. This long since expired.
And he can raise that in a state habeas?
Well, I think he's raising ineffective assistance of his appellate counsel, Mr. Scally, for not giving him that advice, even though it has to do with another court, I suppose, or another proceeding.
Post-appellate relief is what it sounds like to me, and it's based on failure to pursue a federal habeas or to advise him about it.
That's it.
Is that cognizable in a state habeas proceeding?
Giving him advice as his appellate lawyer on his next steps. Yeah.
Well, maybe you can cite me some cases that would persuade me about that, Mr. Carson, but I don't know that flies in a state habeas.
I'll look at it, Judge, see if I can send you some.
Okay.
And Mr. Sapp, anyway, and Mr. Sapp, before today, had you, I know you're intimately familiar with the case, but did you review the trial transcript again and all the pleadings and things that have been filed?
Yes, sir.
Okay. And between what was said from your trial counsel, Mr. McIlvain, and your appellate counsel, Mr. Scally, did you agree with anything they said?
Excuse me, say that again. Repeat that question.
Yeah, I'm sorry, it's a little confusing. You listened to both your prior attorneys testify a few moments ago this morning, and I asked them questions about various involvement in both your trial case and in your appeals case. Did you agree with anything that was said by them?
No.
Okay. All right. Judge, those are all the questions I've got, subject to any redirect.
Ms. McCandless, any questions for Mr. Sapp?
No questions, Your Honor.
All right. Any other evidence, Mr. Carson?
Judge. I believe there's some exhibits from the Attorney General maybe, but that's it.
Well, I mean, from you, nothing else from the
No,
petitioner?
Judge, no.
All right, so you rest, Ms. McCandless?
Yes, Your Honor, I have 10 exhibits.
And Judge, I think she already shared them with me and we don't have an objection.
All right, Ms. McCandless, I'll let you list the exhibits.
Okay. Exhibit 1 is the clerk's record. Exhibit 2 is the volume 1 of the jury trial transcript. Exhibit 3 is the jury trial transcript volume 2. Exhibit 4 is the jury trial transcript volume 3. Exhibit 5 is the jury trial transcript volume 4. Exhibit 6 is the jury trial transcript volume 5. Exhibit 7 is the sentencing transcript. Response exhibit appellant's brief is exhibit 8. Response exhibit 9 is the Attorney General's appellee's brief. And response exhibit 10 is the appellee's brief done by the district attorney. And that is all our documents, Your Honor.
Okay. And they're all admitted by agreement.
That's correct, Judge. No objections.
Okay. Anything else, Ms. McCandless, from the Attorney General?
We have no further evidence, Your Honor.
Okay, so you rest, Mr. Carson. You'll file a brief?
Judge, I will. I'd like to brief the court on that issue of the federal habeas.
I think that's a good idea.
Yeah.
How much time you want?
Is 30 days asking too much?
No, I doubt if I'll get a chance to look at it between now and 30 days, so that's fine.
Thank you, Judge.
Ms. McCandless, you can brief anything you want as well.
Okay, thank you, Your Honor. Could we do it as a response brief?
Sure. You want 30 days after that?
Yes, Your Honor.
Okay. All right.
Thank you, Judge.
In that case, we'll be in recess, Mr. Carson. Unless you want to stick around, learn a little more habeas law, you can be excused also.
And Judge, can I ask you, just generally speaking, I had another case that was continued. Were those all going to that June date, or do we not know yet?
I think the one that was continued, the other one that was continued for you is going to the May calendar. Rachel, is that right?
McCoy got continued to October.
Oh, that's right. You asked for more than.
I think it was
Yeah.
6 months.
We did, yeah.
So yeah, so it's on the October calendar. I think it's in the order, which you probably hadn't gotten yet.
Yeah, I'll look for it, Judge. Thank you, Rachel. I'll look for it.
Okay.
All right, thank you, guys.
All right, Mr. Sapp can be excused also. So let's see what we got left here. Is Mr. Zell with us?
He is, Your Honor.
You ready in the Jacinto Flowers case?
Judge, I don't see our witness.
Can y'all hear me? Can you hear me?
Yeah, we can hear you, but we can't see you.
Okay, I don't know why you can't see me, but that's probably a good thing. I've got a voice made for radio, a face for radio. But the witness had a conflict, and he said he would be available later. So I don't know. I mean, you know, that's subject to. I can look and see. I can't remember where he had the conflict at. I can look. That's what he said. It would be after. He said after 10. Let me look real quick, and I can find out where that is. That's.
I think we only have one other case, if I'm not mistaken.
And the other thing
Your
is,
Honor.
Judge, I think we actually started this hearing in December, and the witness had technical issues. So this was and I think we stopped it. So does anybody have any recollection or any notes of that? But because I have notes that I got a certain distance in examining him, and then he had technical issues. So I don't know if that rings a bell for anybody as well.
I'm not sure I was residing in December.
It was Judge
That's
Russell.
what we have.
It was Judge Russell.
Okay. Well, I don't have Judge Russell's notes, that's for sure.
No, no.
But I can get the transcript.
Sure. I just wanted to make sure. He's in Houston County. Actually, he said he's in Houston at 10 o'clock. His actually hearing starts at 10 o'clock. So I don't know if this is going to be something that is, if we finish, if the court wants to stick around, probably doesn't want to stick around. We can always, it's fine whenever we want to do it, obviously.
Why don't we take up our other case?
Okay.
I can figure out which one it is.
There's actually three, Your Honor. The Brock case, the Newsom case, and you wanted to bring out Mr. Cook and let him know about the continuance.
Right. Let's bring up Mr. Cook right now. That'll be quick. Oh, the Brock case, yeah, I see that. Good morning, sir. Are you Ty Cook?
Yes, sir. Yes, Your Honor.
Mr. Cook, we got a request from you to continue this habeas hearing. It came in just a few days ago, so there wasn't enough time to get an order back to you to let you know. But your motion to continue has been granted, so we're going to move it to another calendar. How much time are you asking for?
Sir, I was requesting for a 90-day continuation.
90 days? Okay.
Yes,
Rachel,
sir.
do we know when that would be?
Would July 27th work?
Yes, ma'am.
July 22nd, Mr. Cook?
27th.
27th. Yes, ma'am. Yes, Your Honor.
All right, tentatively, we'll say July 27th. I've got to double check the dates in the calendar, but that approximately in that range, okay?
Yes, sir.
All right, so then you can be excused.
All right, have a great day.
Okay. And so we got Mr. Brock and we got Mr. Newsom.
Yes, Your Honor.
Well, which one y'all want? Doesn't matter to me.
Maybe Mr. Newsom.
It looks like a continuation hearing. All right, can we get Mr. Newsom? My docket says he's in Sumter County. Is that right? Oh, there you are. Okay. Mr. Newsom, is that you?
Yes, sir.
Will they let you take your mask off there? We could probably understand you a little bit better. And you're in Sumter County now?
Yes, sir.
But when this started, you must have been in Tattnall County, right?
Yes, sir.
Okay. So we're here for the continuation of your habeas hearing. Are you ready to go?
Yes, sir.
Okay. So I was not on the first part of this, so I don't know what was done and what wasn't done. Maybe somebody can fill me in a little bit.
I can, Your Honor.
Hang on one second. Let me get my notes organized here. Okay. So the first part of that hearing was August 25th of last year, right?
Yes, Your Honor.
All right, Ms. McCandless, do you want to tell me what we did?
Yes, Your Honor. He is challenging his 2017 Floyd County jury trial convictions for armed robbery, which were affirmed on appeal in Newsom versus State 355 GA App 13. And at the last hearing, the witness's testimony was already taken and the documents were admitted. So but petitioner asked for a continuance. And so we're just.
So who was the witness? Trial counsel or appellate counsel?
Appellate counsel, Your Honor, David Marshall.
Okay. Would you give me that citation again to the appellate opinion?
Yes, Newsom versus State 355 GA APP 13 2020.
Page 13, 2020.
Yes, Your Honor.
All right, so Mr. Newsom, I guess this is your side of the case. Do you have any evidence to offer? Do you wish to testify?
Yes, sir.
Would you raise your right hand so you can be sworn? Swear the evidence you're about to give in this hearing should be the truth, so help you God?
Yes, sir, I do.
Okay. All right, you may proceed.
Okay, really just the main thing is ground one when they charged me armed robbery and robbery for the same charge.
I'm having a little bit of difficulty hearing you, Mr. Newsom. Can you either get closer to the microphone or speak a little louder?
Yes, sir. Can you hear me now?
I can hear you, but it's not as loud as I'd like it, but go ahead.
Okay, well, the main thing was the first ground I raised was ground one, which I had raised. Basically, they charged me with armed robbery and robbery for the same incident, basically.
Wait a minute, I didn't understand. You charged with armed robbery and something. What else did you say?
Armed robbery and robbery for the same thing.
Okay.
I was convicted of, you know.
And you were convicted of armed robbery, right?
And robbery for the same thing.
Convicted of both, okay.
Yes, sir. And from my understanding, I'm sure to get the best outcome of those two situations. But, and then, you know, then the best and version, they already read my grounds out, so, but that was the main thing I was stressed with.
That's the main thing you raise in here is that you were convicted of armed robbery and robbery, and it was the same offense or the same.
As I know, see, but the rest of the grounds too, but there's mostly,
I'm sorry, I'm Ms. Newsom. I'm really having trouble hearing you.
No, the rest of the grounds too, but that's the main thing I'm trying to just point out, really.
So there are other grounds in your petition, but the main thing you're trying to point out is that you were convicted of both robbery and armed robbery for the same event. Is that what you're saying?
Yes, sir.
Okay. So, Mr. Newsom, you want to just stand on your petition for the other grounds?
Yes, sir.
Okay. All right. Is there anything else you want to say?
No, sir.
Okay. Ms. McCandless, do you want to cross-examine?
No, Your Honor.
All right. Anything else then, Mr. Newsom, for you before we adjourn? No?
No, I'm fine, sir.
Okay. All right, then we will adjourn this hearing. I'll get the transcript of the first hearing and go over that, and then I should be in a position to rule on the case, unless I'm missing something. That seems like it. Okay, then in that case, we'll be in recess, and Mr. Newsom, you can be excused.
Okay, thank you.
All right. Let's see. You know what? It's 10:30. Let's take a 5-minute break, and we'll come back, and we have Mr. Brock left, and we have Mr. Zell's case, which is can't remember what. Oh, Mr. Flowers, I think.
Yes, sir.
Okay, so a 5-minute break, and we'll come back. All right, let's see where we stand now. Before we get started with the next habeas hearing, Ms. Smith, I have a question for you. So I am scheduled to preside at a trial in Tattnall County tomorrow. And what I wanted to ask you whether is your opinion about whether you thought it would be okay for me to preside from my living room here in Savannah instead of riding up to Reedsville, because it'd be a whole lot easier.
I've never seen anything speaking about whether you physically have to be present. It's the defendant that has to be present.
Yeah, it's probably true, but I'm a little reluctant to go
I
down.
mean, I think if that's something, if you were, my understanding is just years ago, you're appointed as a senior judge to an individual case. You're not, it's not like you were riding circuit anymore. Say, had you been in a multi-county circuit. And that's the difference, because I know that an active Superior Court judge could sit in any county within that circuit and entertain anything. Senior judges, my understanding, it's been a while, but it's on a case-by-case basis.
You're taking this a lot more seriously than I expected.
And just, I mean, and I think if everybody's aware of it, because I had been told that one of your colleagues was actually perhaps even doing arraignments from her house on Sea Island during the pandemic. I can't speak to that.
Well, we do a lot of remote hearings. I mean, we've done that, but everybody's remote on those things.
And I think so. I mean, I think under the circumstances, as long as you're able to see and hear everything, I don't see a problem, based on what comes to mind this morning.
Well, I appreciate that. The flip side of that is that you might be defending that position in a habeas case one of these days. Let's not go down that road. I'll just drive to Reedsville tomorrow.
There is that the defendant has the right to a public trial, but there's also First Amendment right of the public. But they've never talked about where the judge is, and I've not looked at those pandemic rules. I'll just throw that out there.
Okay, well, maybe next time, but not tomorrow. All right, so let's go on. I guess Mr. Zell doesn't have his witness yet. So the first case is, the only other case that's left is James Brock. Mr. Brock, is that you there?
Yes, sir.
Okay, you ready to go forward with your case?
Yes, sir.
All right, Mr. Brock, just give me 1 minute to get my notes organized here and we'll get started. All right, Mr. Brock, are you intending to testify in this hearing or only argue or both?
Only argue.
Only argue, so you don't want to be sworn?
No, sir.
Okay, all right, that's fine. All right, so Mr. Brock, it's your case, so tell me whatever it is you want to tell me.
Well, I'm here to defend indictment number SU 09 CR 3127. My issue is that I was prosecuted for this case in secret. There were several motions, several documents, several court hearings that were on file, and I didn't attend these hearings. I even all the way up to a conviction. I was convicted for this charge, but I wasn't present, you know. And
You had a trial and you weren't present?
yes, sir. Yes, sir. The trial that I had, I wasn't present for, but all the documentation on the docket shows that they initiated a prosecution process and found a final disposition, which was guilty. But I was unaware of this entire process. I discovered this process when the docket was actually given to me, and I appealed it.
Mr. Brock, can you hang on for 1 second?
Yes, sir.
Unfortunately, some lawn equipment has just fired up next door, and I'm having a hard time understanding Mr. Brock, and I wouldn't be surprised if y'all are having a hard time hearing me. Mr. Brock, let's go back for a second. Did I understand you to say that you had a trial that you weren't present for, and that other motions and documents were filed that you were not aware of or you weren't present for? Is that right?
Yes, sir. I had a trial without me being there. Basically, what I'm saying is that Muskogee County faked the entire prosecution process, and
Muskogee County did what to the entire process?
they faked the process. Like
They
they filed
faked it.
doc.
Okay.
Yes, sir. Without me being there, I'm guilty for this indictment, but I wasn't present. And they even went as far as trying to tell me that I wasn't indicted at all, and that I was just in the Superior Court before the Superior Court judge, and that my attorney filed an entry of appearance, and I'm sitting here before Superior Court without jurisdiction. They denied having the jurisdiction over my case. They wanted to convince me that I wasn't indicted in 2009, but I was, in order for them to go get a subsequent indictment in 2010 and try me twice for the same offense. So I'm appealing the first indictment that I wasn't present for, the one that they faked the process for.
Okay, Mr. Brock, I'm having a hard time understanding this. There was a subsequent indictment.
Yeah,
Is that what
yes,
you're
sir.
saying?
Yes, sir.
And you were convicted on the second indictment or the first?
Both of them.
You're convicted, sentenced on both?
Yes, sir.
And you're saying the first one was done entirely in secret?
Yes, sir.
And what about the second one?
The second one I was present for.
So you're not complaining about the second one?
I mean, the second one was bogus by the first one.
Was bogus?
Yes, sir.
Why was it bogus?
Because the first one, if you already tried me before I went in the courtroom, the second one can't stand. That's double jeopardy.
Okay. So just to make sure I understand what you're saying, because the first indictment that you were tried and convicted and sentenced on was all done in secret, that's got to be thrown out. But that makes the second one bogus because you can't be tried and convicted for the same thing a second time. Is that your point?
Yes, sir.
Okay. All right, Mr. Brock, do you have any documents or anything you want to enter into the record?
I sent the clerk all the documents that I wanted to enter on the record, and they filed. They stamped and filed.
Okay, so they were filed. Ms. Smith, any objection to those?
No, Your Honor, and I would note for purposes of the record, it looks like it's a transcript of a bond hearing that was conducted on October 1, 2010. The case number on it is 2009 CR 3127. And that's what he filed, and he filed a brief in support of this claim that this 2009 is the faked indictment and the whole thing has been a fraud. We have no objection to the transcript of this bond hearing coming in.
Okay, then that is admitted.
Your Honor, I also
Yes.
I also sent with the
Yes, sir.
the transcript like motions from the Supreme Court saying that talking about a superseding indictment showing that I was actually indicted 2 times for the same charge because the lower court, once I brought this to their attention, they denied indicting me altogether in 2009, which strips them of subject matter jurisdiction, but they actually tried that to deny me being indicted in 2009. But that's impossible for me not to be indicted in 2009 because I was going before a Superior Court judge for an entire year. I had an attorney for an entire year and a district attorney for an entire year. So how did I get put on the Superior Court docket without an indictment? That's the first step. In order to be in the Superior Court, you have to be indicted. That's what gives the Superior Court jurisdiction. And my lawyer filed an entry of appearance, a waiver of arraignment, and then we get in the courtroom and they're talking about I wasn't indicted. I'm like, that's impossible that no one in here understands that I have an indictment before this courtroom. But like I said, that was to trick me into believing that I wasn't indicted so they can go get a subsequent indictment and try me for the same offense. I understand now. I worked on several cases just like this all over the state of Georgia. Savannah, Georgia, Fulton County, Georgia. I
You
don't know.
worked on their cases?
Yes, sir. Yes, sir.
What do
I
you mean you
worked
worked on cases?
like inmates bring me their cases and I find discrepancies in their cases and help them get their cases overturned. But I seen
And
this
they do
secret.
that in Savannah, you're saying?
Say that again?
You're saying they do that in Savannah? They trick people
Oh yeah.
with it?
Yes, sir. I got a case right here from Savannah, Georgia, where it was 3 defendants placed on 3 different true bills with 3 different docket numbers, and they were all tried at the same time. So that's 9 for 1. Each person was found guilty 3 times for the same charge. That's 9 for 1. That's what all this is about, taxes. If I can inflate my caseload, then I can get paid more taxes. So it's not about our guilt or our innocence. It's about how much money or how much revenue we're going to collect off these convictions, off these prosecution processes. The judge gets 2, the DA gets 2, the public defender's office gets 2, the clerk's office gets 2. Everybody gets 2 for 1 for faking these caseloads. And this is what I'm here for. This is what I discovered. And
So just to be clear, you think the prosecutors get paid more if they have bigger caseloads?
yes, sir. Every government entity is funded by taxes. It's a service. You're providing a service for the public. So once you show the auditor, this is how many cases I have, then they're going to write it off. The Bureau of the Budget is going to write it off. And they're going to say, okay, well, good job. You did do this many cases. And these cases are worth this much amount of money. But if I can double up on everybody, then I get more money. Or if I can triple up on everybody, then I get more money. And not just the DA office, but every office. Every office. I'm a victim of that right now. I've been locked up 13 years for that. I'm actually innocent of the charges. I put this in my
Well, a
motion.
minute ago, you said you were guilty of the indictment, you told me. I wrote it down in quotes.
No, sir, I've never said that. We have a court reporter. I've never said I was guilty of anything.
We do have a court reporter, and I'll check the record when I get it to see exactly what you said, but
Yeah,
that's what I wrote down.
Okay, I'm pretty sure you did because that case that I got from Savannah, Georgia, is actually your case, sir.
Really?
Yes, sir.
What's the case?
I'll read it off. It's the state of Georgia versus Devontae Bonds, Joshua Ramsey, and Devon Tarver. Case number CR 13-1782, CR 13-1786, CR 13-1781. These 3 men were co-defendants. They were given 3 different true bills of indictments for 1 charge. It only takes 1. And when I reviewed their case, I'm like, that's impossible for a grand jury to indict them so close in sequence. 1781, 1782. If the prosecutor presents evidence for these men before this grand jury, they say we passed a true bill, and then turn around and say next case and say we're going to prosecute this same case, somebody in the grand jury would say, wait a minute, we just passed a true bill on this case moments ago. Moments ago, all these indictments were indicted by the same grand jury.
Okay.
1782, 81, and 86.
You say it was my case, huh?
Yes, sir. It was your case. I researched it.
So it looks like, from what you're saying, it sounds like somebody owes me some money, doesn't it?
Somebody owes you some money?
Well, you said I get paid for each one of them, and I'm pretty sure I didn't.
Oh, yeah. Pretty sure you did.
Okay.
Right now, I'm in habeas corpus twice under 2017 HC60 GC and now 2017 HC60 MK, which I wasn't put on your docket in 2017 because you wasn't even a judge in this county in 2017. You were somewhere else. You were in Savannah, Georgia, but my case number changed again. So now I'm on two different dockets for habeas corpus, 2 for 1. I guess it's 2 for 1 all the way up, huh? All the way up to the appellate court. That's why I can't get no judgments.
Right.
Yeah,
You must
I know.
be right.
No, I am.
All right. So, is that your case? I mean,
Yes, sir. That's my argument. That's my argument, sir. I'm a victim of a judicial scam, and I would like my case reversed. The docket shows it. The docket shows it. 2009 will show you that I've been convicted, and the 2010 will show you I've been convicted. The court has access to it, the uniformity. A click of a button to free me.
All right. Anything else you want to say before I allow the attorney? All right. Ms. Smith.
Okay. Mr. Brock, did you have a bench trial before Judge Peters in March 2011?
Yes, ma'am.
And you were convicted of 2 counts of murder. One was the murder of Taisha McNair, and the other was the murder of Terrence Clark.
Yes, ma'am.
And you were also convicted of sorry, Your Honor. And there were some other charges, and there was a claim of firearm possession charge that was null prost afterwards. Was that correct?
Yes, ma'am.
And yeah, you got convicted of theft by receiving, and you got 5 years for that. And you were convicted of 2 counts of possession of a firearm during commission of a crime and got 5 years each for those. Is that correct?
Yes, ma'am.
And the judge sentenced you to life without parole for each malice murder, and those run concurrent?
Yes, ma'am.
And then after the trial, you elected to represent yourself. So you handled the motion for new trial and you handled your appeal?
Yes, ma'am.
And your appeal was dismissed because you never filed an appellant's brief?
Well, I did file an appellate brief, but the Supreme Court sent my notice to a prison that I wasn't at, and then dismissed my case. I guess to avoid hearing these grounds, because I filed a motion for like continuance or motion for reconsideration, explaining to them, you sent my notice somewhere else, so there's no way that I could have filed a appellate brief within a proper time. But they ignored it.
Okay. And so we've already had a hearing in this case back in July 2018. We were in front of Judge Bolin, Bolin, who was presiding that day.
Well, she stopped my hearing earlier. I didn't get a chance to speak at all. She just said that she was gonna make a ruling based on what was written in my petition. But I didn't get a chance to argue my motion at all when everything started. Ma'am?
Did you get a transcript of the hearing, and didn't we put in the records from your trial at that hearing? It's about seven volumes worth of records from your criminal trial.
But that's not for the case that I'm filing today.
That's not my question, Mr. Brock. You got a copy of all those records, and have you looked at them?
That's not the record that we're discussing today. So it doesn't matter if I got a copy.
Did you look at page 197 of volume 1 of the habeas transcript? This is the judge's order on the motion for new trial. And it talks about this whole indictment issue because you raised it after the trial, didn't you? The same double jeopardy claim?
Yes, I did.
And didn't the judge say that you were bound over on November 13, 2009, and the case was assigned the number of SU 09CR3127? That's paragraph 1 of the order. But then the judge found that you were in fact indicted almost a year later on October 26, 2010 for 12 counts, including murder. That was the case number SU 10CR2751, and that's the case you were tried and convicted in. You have a copy of that?
Yes, ma'am.
So there never was an indictment under this case number. They just gave it this 2009 case number.
No, ma'am, that's not the truth.
Do you have a copy of this 2009 indictment?
No, ma'am, but I'm pretty sure.
Do you have a transcript of these secret proceedings?
No, ma'am, but I have motions.
So how do you know what, Mr. Brock, how do you know you were convicted if you don't have any paperwork?
I have all the motions. I have my motion for bond. I have my motion, my Rule of 9 side. I have my entry appearance. I have a motion for habeas corpus. I have all my motions on this under this docket number. There's no rule. There's no rule that allows a case number to be created in the Superior Court without an indictment. Rule 39.38 says that a unique number is assigned to an indictment. So I can't have one without the other.
But you don't have a sentence with the 2009 case number on it? You just got motions. Is that a fair statement? Is that what you're saying?
Yes, ma'am, but I did.
So you don't have a transcript of any jury trial or bench trial under this 2009 case number?
No, ma'am, they hiding it from me.
I have no further questions at this time, Your Honor. We stand, no further questions of Mr. Brock at this time. Sorry.
I do have a letter from the Department of Correction that says that this case number is a part of my institutional inmate file. My counselor actually took me in the office, turned the computer screen around, and showed me both convictions in the NCIC database, the GCIC database. So it's there. I mean, but if you want to continue to help them hide it, go ahead. I can't do anything about that. But you know, like I know, the rules say that I can't have go into Superior Court without an indictment. They come out together. So I guess you're defending a lack of what? Due process, a lack of jurisdiction. They're wrong. That's wrong. And you know that.
Okay, Ms. Smith, does the Attorney General's office have any other evidence to offer?
No, Your Honor. We'll stand on the record that was established at the 2018 hearing. In addition to, I think last month we were before you and added the transcript showing where Mr. Brock elected, in fact, to represent himself post-trial and on appeal. He was advised of the dangers of proceeding pro se. The other grounds that he raised have not been addressed, and we would like the opportunity to submit a post-hearing brief for you on those rather than spend court time arguing those and with him today.
Okay, that's fine. All right, Ms. Smith, how much time would you like?
30 days from today, Your Honor, I think we can get everything in.
Okay. Mr. Brock, you can file anything you'd like to file within the 30 days as well.
All right.
I'll get that get the earlier record, which I don't have right now, but I guess that's on Peach Court, is it? Could be.
Not the whole transcript. I'll have to
Okay.
get that to you.
All right, we'll get that transcript. And I'll look for a brief from both sides in about 30 days.
Thank you, Your Honor.
Okay.
Your Honor, I have
Yes,
a
sir.
question.
Yes.
During the appellate process, the clerk has an obligation to send the record to the appellate court. So I'm not understanding why this is not being seen, because you have my record before you. The Attorney General has this record before you, but you're denying seeing on the record that I was indicted. You're denying seeing on the record that I was convicted. It's there.
Brock, I'm not denying anything. I'm just telling you, I haven't seen the documents yet. These were 2018. I wasn't involved in this case then.
I'm talking about the clerk's docket, the clerk's record. The clerk has to forward the record to you.
Mr. Brock, I'm not sure I understand what you're asking, but I don't think that's something I can answer for you.
Yeah, I know.
All right, in that case, we'll be in recess of this hearing, and I'll look for the briefs in 30 days. All right, Mr. Zell.
I'm here, but I don't see, unless Nicholas White is available. His hearing was supposed to be at 10 at Houston. So if we're the last one, I don't know what else to do other than to just ask that we continue it.
I haven't seen him either. It's, what time is it? 11 o'clock.
Yeah, I'm always reluctant when somebody says they have a conflict and they'll be able to, you know how court is. Your case may start at 10 and you may be number 50 on the calendar, or who knows what happens, but that's all.
I have a wee bit of experience with that.
Yeah, I think you do. I think you do. So this was started in December 21st. We didn't really get too much into the substance other than just background, but I guess we can move it to May. It's ready to go, just other than that.
All right, well, let's just move it to the May calendar then. I'll just mark that the witness was unavailable. And what's the date in May?
I believe it's the 25th.
That's right.
What, the 25th?
Yes.
Yes, sir.
Okay, we'll move it to May 25th then.
You will see my name quite a bit on that calendar.
Well, okay.
And I think they'll all be ready to go but one, but yeah, I think so.
Okay, is this Mr. Flowers? Mr. Flowers, it turns out that your witness, Mr. White, is not available this morning. We've been waiting around for him, but apparently he's tied up in another courtroom. So we're gonna move this hearing to the May calendar, which is on May 25th.
Okay. All right.
Okay.
I explained that to him yesterday, Judge, that might be a possibility that this case had a conflict.
Well,
So
unfortunately, that's what happened. So we'll finish it up then.
All right.
All right. In that case, Mr. Flowers can be excused, and if I haven't missed anything, I think that's the docket, right?
By my notes, it is, Your Honor.
And mine also. Rachel, is that everything?
Yes, sir. That's it.
Okay. Well, I'll see the
thanks.
clerk's office folks in Tattnall tomorrow morning. Rachel, you won't be there.
No, I'll be in Claxton. I won't see.
I had a feeling. Okay. Well, if I have any emergencies, I might call you.
Okay.
All right. Then in that event, we will be in recess today.
Thank you, Judge. Good to see you.
Okay. Same here.